I just wanted to introduce our Unit 4, which is on civil rights and civil liberties. And today we're going to talk about a particularly important topic, the topic of selective incorporation. Before we actually get into that, though, I do want to spend a little bit of time just defining civil rights and civil liberties. And this can be a little confusing, particularly because of the source of each. So when we talk about civil rights, what we're talking about is we're talking about rights that are not applied to everyone equally. So, for example, if you are part of some specific, group or demographic that does not have access to the same rights as the people at large, like that is a civil rights issue. So, race relationships, sex, religion, those are all civil rights issues, particularly if a certain group has rights that another group does not. That's when it becomes a civil rights issue. Civil liberties, we're talking about the fundamental freedoms that everyone has. So, for example, an issue that's related to freedom of speech is a civil liberties issue. Now, if that freedom of speech does not necessarily have, or if not every group has the same access to freedom of speech, well, that's a civil liberties issue because it's a freedom of speech Bill of Rights issue, but it's also a civil rights issue because it's not being applied equitably to all groups. What gets confusing, though, is that the source of our civil liberties is our Bill of Rights, which is different than civil rights. See, makes sense, right? All right, and so today we're going to look at the big picture, and the big picture is we're going to look at two questions, and it's what is the Bill of Rights, and who does it apply to? I know I cheated because that's basically two questions in one, but we're going to say it's one. And the second is what is selective incorporation and why is it important? Oh, another two questions. So really, we're going to look at four questions, but 2 bullet points. So before we begin, let's actually then define the Bill of Rights and start looking at this question of who it applies to, and that will actually ultimately lead us to understanding what selective incorporation is and why it is important. And so, to begin with, the Bill of Rights is the first 10 amendments to the Constitution. And if you recall back over the ratification debates, there was a serious debate about whether or not the US Constitution needed a Bill of Rights. And so there were the anti-federalists, those who opposed the Constitution, and they essentially argued that this new government under the Constitution created a more powerful government, and that more powerful government was a threat to individual liberty and to states' powers. And so they argued that a Bill of Rights would protect these fundamental rights, fundamental liberties. They wanted things like freedom of speech and freedom of religion and freedom from unreasonable searches and seizures to be codified into the Constitution. They also wanted to ensure that with federalism, that state power was also reserved and codified into the Constitution as well. Now, the Federalists responded by arguing that essentially there was a danger to enumerating rights. By listing certain rights, what you did was limit rights. There was no way you could possibly list every single right and freedom that Americans were meant to enjoy. And so what happens is once you create a list, you then limit the amount of rights, because if it's not on the list, then the assumption that it's not there. And so their argument is that this Constitution limits the powers of the government by enumerating the powers of each branch, that through federalism, it creates a clear separation between federal and state power. And so you don't need to actually list individual rights and individual liberty because the Constitution is not, taking them away. And so one of the big questions that we have is who does the Bill of Rights apply to? So the voice of the anti-federalists won out, the federalists overall, because the Constitution was ratified, and with it came 10 amendments. Now the first 8 deal specifically with individual liberties that we have. The 9th Amendment addresses that essential Federalist counter argument, which is that, again, by listing rights, you are limiting rights. And so the Ninth Amendment says the enumeration of certain rights cannot be used to limit the rights of the people. So essentially that the Ninth Amendment is saying that the Bill of Rights is not a complete list, that there are other rights that the people can enjoy. So just because it's not on the Bill of Rights does not mean that you don't have it. And then the 10th Amendment protects the states' rights. The 10th Amendment says that all power is not given to the states nor prohibited in the Constitution, or sorry, all power is not given to the federal government in the Constitution nor prohibited to the states are reserved to the states and to the people. Meaning that if the Constitution does not give the federal government power as enumerated, as listed in the Constitution, that those powers automatically go to the states and to the people. And so if there was ever a question about, this principle of federalism in the Constitution, which there shouldn't have been, but if there was, the 10th Amendment ensures that federalism is going to be a cornerstone of constitutional principles. All right, and so the question then is, who does the Bill of Rights apply to? So the Constitution is a contract, and the contract between the people and the government. And the question then becomes, what government? So, the question, essentially put another way, is that if the First Amendment guarantees you freedom of speech, what if a state limits your freedom of speech? Not the federal government. What if a state limits your freedom of speech? So we know that the Constitution is a contract between the people and the government. The question is, what government? And so the initial interpretation, as it came before the Supreme Court in 1833, we have to go to the city of Baltimore and a guy who built a pier. Now, Baltimore at the time was renovating its harbor. It was expanding it. It was dredging out the harbor to make way for these new steamships that were taking in. Baltimore wanted to become an increased commercial center for trade. And so they dredged the harbor, and in doing so, they destroyed this guy's pier. Now, the question, first of all, is can the federal government take private property for public use? And the answer is, well, yes. In fact, the Fifth Amendment says just that private property can be taken for public use with just compensation. So as long as the government gives you fair market value and compensation for their private property, your private property that they're going to be taken, well, they can do so in the public interest. So for example, if Arizona decides to expand the 202 and your house is in the way, well, that's the power of eminent domain, the power to take private property for public use. Now the problem in the Barron v. Baltimore case is that the city of Baltimore did not compensate him. And so he pulled out his pocket constitution like we all do, and he goes to the Fifth Amendment and he sees that just compensation part of the eminent domain clause, and he sues. And it goes all the way to the Supreme Court. And then the Supreme Court basically throws out the guy's case and essentially argues that the Fifth Amendment does not apply, and he does not have a case because the federal government did not take his land. The state did. So if he needed to sue, he needed to sue the state, and not under the federal constitution. He needed to sue the state under Maryland's constitution, and Maryland's constitution just so happened to not have an eminent domain clause, and therefore the city of Baltimore was perfectly just in taking this guy's property for public use without actual just compensation. And so this 1833 case, Barron v. Baltimore, when it looks at the question of who does the Bill of Rights apply to, pretty clearly answers that question, that it applies to the people and the federal government only, not the states. And so your freedom of speech in the First Amendment protects you from the federal government. Your Second Amendment protects you from the federal government. Your Fourth Amendment of unreasonable searches and seizures protects you from the federal government. But the Bill of Rights protects people from the federal government. not from their state governments. Now, the Civil War occurs, and following the Civil War, we add the 14th Amendment to the Constitution. And the 13th, 14th, and 15th Amendments actually are all of these Civil War amendments, and all of them fundamentally change the relationship between the national government and the states. Before, whereas certain rights fell under states' rights, the 13th Amendment tells states that you can't have slavery even if you want to. The 15th Amendment tells states that you can't deny the right to vote based upon race, even if you want to. And the 14th Amendment really alludes to something, different. Now, the 14th Amendment does a bunch of things, probably most commonly known as establishes citizenship, but in that 14th Amendment are three very important clauses, and every single one of them restricts states. And so it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, in fact, in Article 4 of the Constitution, there is a privileges and immunities clause already in there. And now the 14th Amendment is taking that clause and it is specifically telling states that they cannot deny privileges or immunities. Nor shall any state deprive any person of life, liberty, or property without due process of law. There's a due process clause in the Fifth Amendment of the Constitution. But now that due process clause is being applied to the states, not the federal government. And then nor shall any state, is kind of implied there, nor shall any state deny to any person within its jurisdiction the equal protection under the law. And so states are now required to provide privileges or immunities to its citizens. They're required to give due process to any person. It doesn't say citizens, any person. And they're required to provide equal protection to any person. And so the 14th Amendment really alludes to something, different. And that suddenly the Bill of Rights, the liberties in the due process clause cannot be denied to people by the states. But if you know your history and Reconstruction that follows in the early part of the 20th century, you would know that states very effectively denied both due process and equal protection under the law. This was the time of Jim Crow and segregation, separate but equal. And so the 14th Amendment alluded to something different, but it didn't necessarily fundamentally change. And that's going to come later. And that case, that important case, which changes the court's interpretation of the 14th Amendment, is the Supreme Court case of Gitlow versus New York. And so what happens is New York passes a sedition law. The sedition law makes it illegal to criticize the government. Mr. Gitlow decides to give an anti-war, anti-draft speech. In fact, he is advocating for people to do something illegal. He's advocating for people to dodge the draft. And so New York, under their sedition law, charges Mr. Gitlow and convicts him of sedition. And Gitlow countersues and argues that law, that sedition law of New York, was a violation of his First Amendment rights. And what happens is when it gets to the court does not look at this in the same way that Barron v. Baltimore was looked at. If Barron v. Baltimore was the precedent, then simply they would have once again thrown out his case and said, hey, take it up with New York and your New York Constitution. And does your New York Constitution have a First Amendment freedom? And in terms of freedom of speech, let's look there. It's really between you and the states. The federal government's not taking it away. And yet what happens is they actually decide to hold New York to the First Amendment freedom of speech standard in the Constitution, using the 14th Amendment's due process clause. If the 14th Amendment says no state can deny to any person life, liberty, in this case, that's the most important part, or property without due process of law, is New York's sedition law a violation of the First Amendment of the Constitution? Now, in the end, they decided that it was not a violation, but they did say that New York was bound to the First Amendment. And so what happened for the very first time in history is this process of selective incorporation. Selective incorporation is the applying of the Bill of Rights to the states on a case-by-case basis using the Due Process Clause of the 14th Amendment. So let's just break this down a little bit more. So incorporation is the application part. What we're doing is we are incorporating the Bill of Rights. We are applying the Bill of Rights to the states. We're binding the states to the freedoms enumerated in the Bill of Rights. But it is selective. It is on a case-by-case basis. So what has to happen is the Supreme Court has to take a case and then has to decide that that case applies to the states. And it uses, again, the 14th Amendment's Due Process Clause. That is essentially, the power behind this action. And so starting with Gitlow versus New York, the Supreme Court decided to apply freedom of speech to the states. That meant that going forward, states, even if their own constitutions did not protect freedom of speech, that the Bill of Rights of the Constitution ensured that protection to all people. And then 6 years later, they applied freedom of the press. And so what you saw going after 1925 is the Supreme Court taking these cases and deciding which parts of the Bill of Rights apply to the states. And so there are still today like unincorporated rights. Like there are not every single part of the Bill of Rights has been applied to the states. And it is actually very selective. There are times when the Supreme Court might decide not to apply when a case comes up. And then there are times when it is going to apply. And actually the two cases which really highlight that are Palco v. Connecticut and Benton v. Maryland. So Frank Palka, by the way, his actual name was Palka with an A, but a court recorder spelled his name wrong. And so forever in case history, it is Palco versus Connecticut. So Frank Palka engaged in armed robbery. He robbed one of those paymaster general trucks. And in doing so, he also killed several police officers. And so the state of Connecticut charged him with first-degree murder and tried to get the death penalty. But in the end, a jury, despite finding him guilty, would only sentence him to life in prison. And so the state of Connecticut tried him again, and not satisfied with a life sentence. And in this new jury sentenced him to death. Now, Frank Palka and his lawyers sued, and they argued that this violated the Fifth Amendment, which said we have double jeopardy, saying that you cannot be tried for the same crime twice. And it went to the Supreme Court, and the Supreme Court decided not to incorporate the Fifth Amendment's double jeopardy clause. And they basically had him lose, telling him that the Fifth Amendment, in this case, double jeopardy, did not apply under the process of selective incorporation, that Connecticut was free to do what it wanted to do with its own state court system. This was not a federal case. This was not a federal issue, and they executed him. Yet, nearly a little over 20 years later, in Benton versus Maryland, a similar case came up. And in this case, the Supreme Court decided to incorporate the Fifth Amendment's double jeopardy clause, which means that today states cannot, not just the federal government cannot try you for the same crime twice, now states cannot try you for the same crime twice. And so, again, it really is selective. And there's also some cases that have just never been incorporated. The very important Third Amendment has yet to be incorporated and applied to the states. It's why that no quartering quarterly, very important interest group, is still there. And it's not only there to protect you from the federal government, but it's there to actually look to incorporate the Third Amendment. So for example, like what if, the police wanted to commandeer your house and use it to stake out as a kind of a hiding, listening post in order to look at gang activity in a neighborhood? Like, could the police, by court order, essentially commandeer your house? Would that be a Third Amendment issue? Would the state be essentially like quartering, troops? Well, that's a really good question. But the Supreme Court has not incorporated the Third Amendment. The Seventh Amendment has not been incorporated. That's the one that says that you get the right to a trial by jury in civil cases that are worth more than $20. If you decide, if you have a civil case, like a speeding ticket, that's worth more than $20, you do not have a right to trial by jury. In a federal case, you could request a trial by jury in a federal civil case, but because it's not incorporated, it does not apply to the states. Your Eighth Amendment, which prohibits cruel and unusual punishment, has been applied. Your Eighth Amendment, which prevents excessive bail, has not. And so one of the leading cases, one of the kind of big issues today is whether or not that excessive bails and fines should apply to the states. Like, what happens when you might have someone who's homeless, who gets arrested for loitering or vagrancy, and they can't actually post bail. And so while they wait for their case, they are sitting in prison, and they might actually serve more time in prison waiting for their case than the penalty if they are even convicted. And then what, of course, happens even if they're found, innocent. And so does the imposing of cash bail on indigent citizens, is that a violation of the Eighth Amendment's prohibition against excessive bails and fines? And the Supreme Court is yet to declare that it does. It's yet to incorporate that. And so this process of selective incorporation began in 1925 with Gitlow versus New York, and continues. In fact, the most recent incorporation case was the Second Amendment. We'll look at that case, City of Chicago versus McDonald, later next week, I believe. But essentially, one of the main questions we had with the Second Amendment is, does the Second Amendment, is it an individual right or is it a state right? And up until 2010, this constitutional view of this was that essentially your Second Amendment was a state right. And then in 2010, the Supreme Court incorporated the Second Amendment, applying it to the states, meaning the states cannot actually, like the federal government was bound to the Second Amendment, and now states are bound to the Second Amendment, meaning your individual right to keep and bear arms cannot be infringed by now neither the federal government or the state governments, making it an individual protection against both federal and state governments, whereas before it was only a protection against the federal government alone. And so that's actually our most recent incorporation case, big incorporation case. So back to our big picture. Which is, what is the Bill of Rights and who does it apply to? So what's the Bill of Rights? The first 10 amendments to the Constitution. Who does it apply to? Well, that's a trickier question. I mean, we know today that it applies to all people against both the federal government and the states in certain cases, which actually is then our next question, which is, what is selective incorporation? It's the process of applying the Bill of Rights to the states, using the Due Process Clause of the 14th Amendment on a case-by-case basis. And why is this important? Well, first of all, it applies the Bill of Rights to the states. We now are guaranteed fundamental protections in the Bill of Rights against both our national government and our state governments. It's also important because if we want to learn and know about our civil liberties, well, actually understanding the Bill of Rights means something. If without selective incorporation, knowing the Bill of Rights would not actually tell you a lot about your rights. It would tell you about your rights when it came to the federal government, but how many times is the federal government the one that's actually going to be looking to abridge your freedom of speech or to engage in searches and unreasonable searches and seizures? And the answer is, most of our interaction is with the state governments. And so without selective incorporation, if we really wanted to know our rights, well, as a government teacher, I would have to teach you your Arizona Bill of Rights. In fact, we don't actually look at the Arizona Bill of Rights at all. Arizona has a Bill of Rights and mirrors our federal Bill of Rights a whole lot. But But we don't ever look at that, and we don't really have to because of the process of selective incorporation. We don't have to, before we travel to another state, we want to vacation in California, suddenly look at California's Bill of Rights to know what our rights are when we cross it over, into the state of California. Are those rights different than the ones that we enjoy here in Arizona? Again, we don't need to know that because the process of selective incorporation applies and protects our fundamental liberties against the federal government and the state governments as well. All right, so this week we'll be looking specifically at the first several clauses of the First Amendment, which are freedom from the establishment of religion and the free exercise of religion. And but without selective incorporation, looking at those with all these cases we're going to be looking at wouldn't actually mean a whole lot. So I hope you enjoyed this. I hope you learned about the importance of selective incorporation. And again, feel free to ask me any questions you might have.